Welcome, everyone. Mine went blank. It says I'm in the show and everyone can see and hear me. So, welcome, everyone that's listening in. Y'all know how we do. If you're watching live, give us a hashtag live. Tell us where you're from. If you're watching on the replay, give us a hashtag replay and tell us where you're from. This is our third annual estate planning webinar. August is Make a Will Month. I have my very good friend, my sister, the great attorney in South Florida, Sandy Bozeron, is going to tell us about why if you don't have a will, what will happen. This is going to be a series. It's going to start tonight. We're going to also have another one on Thursday, because the scheduling, we had to do 2 this week, and then it'll be every Thursday, same time, same channel at 6:30 p.m. Central, 7:30 p.m. Eastern. So again, everybody, tell us where you're from. Do us a favor, share, hashtag live. You don't want to miss this, because Sandy is very knowledgeable, very encouraging, very inspiring. She's a teacher by trade, by education. That's originally what her profession was, and then she moved into law. So she's still using those teaching skills and abilities in the law. So at this time, Sandy, I'm going to give it over to you. I want you to take it over.
All right. Well, good evening, everyone. Thank you so much for tuning in to our first in our estate planning series for August, which is National Make a Will Month. I believe Troy and I started doing this set of series probably like 2 years ago, I think, maybe 3. Because this is the third. So we really wanted to spend some time during this month encouraging folks to evaluate where you are with your personal decision making, to think a little bit about what it means to organize your affairs, and to consider putting the things together that you need to in order to make a will in the month of August. Now, is everyone going to make a will in the month of August? Probably not. But at least we'll get the conversation going and we'll get you fixated on, hey, what is a will? What does it mean to have a will? What about if I don't have a will? So overall, this series is going to be focused on the question, what happens if you don't have a will? And again, August is National Make a Will Month. I'm here with the Chief Encouragement Officer, Troy Holt. My name is Sandy. I'm an attorney. I'm a assistant professor currently, trying to work with some law students, and I'm trying to continue to do something that I enjoy, which is educating folks on the importance of estate planning. So I'll stop talking. I love when Troy facilitates, which he always does very well. So I'm going to hand it back to you, Troy.
Thanks, Sandy. So, Sandy, we know that this is a very important month, Make a Will Month, and we've had this the third annual event. I think we kind of stumbled upon is Make a Will Month, and so we kind of didn't realize it was Make a Will Month. So why do you think people in America neglect having a will or getting a will?
I think there are a number of different reasons that people don't prepare their will first. But I also think that there's something to be said about why a will seems to be such a big thing, that people feel that it's either not necessary or they feel like if they do it, it's going to basically lead to their death. So I would say one of the major reasons is people are afraid, and they are unaware of what exactly a will does. And they're also unaware of what the problems are that will come about if you don't have a will. And it's funny because so many of us have family members that pass away suddenly or tragically, or, just somebody passes away, of natural causes. And as soon as they pass away, everybody's scrambling to try to figure out, well, what do we do now?
True.
And so the big thing that a will does is give some instruction, right? It is your last will and testament. It gives instructions to your family. It gives instructions, if need be, to the court. And it puts everybody on notice of what your intentions were when it comes to your family, when it comes to your, final destination, right? When it comes to any property that you own, whether it's physical property, whether it's, social media, whether it's investments or stock, whether it's rare jewelry or paintings. It gives people some notice on what it is that you wanted, and so that nobody has to try to kind of guess what you wanted to happen after the person passes away.
So, Sandy, so we live in America, and everybody believes in individual rights. There's some more than others do not want government involvement in any affairs. And what most people don't realize, if they don't have will, what they don't like or what they hate the most is what happens. So why people do not grab a hold that if you don't have a will when you pass, then the government dictates to where your assets go?
Well, what folks don't realize is that if you do not have a will, and if you unfortunately find yourself having to have your affairs go through the court process, there's already a law laid out that handles what happens to your stuff, right? And so in order to prevent people from having great difficulty in figuring out who gets what and how things are divided and when things are divided, each state has laws that are focused on those who do not have a will. It's either called intestacy or you'll hear the word intestate. And it basically means that you don't have a document that gives instructions to anyone about what you want to happen upon your passing. And so what the law has carved out is instructions on what happens. So here in the state of Florida, for example, there are literal Florida statutes that iron out step by step. Well, if this person passes away, who's the first person to receive? Then if that person doesn't exist or they've passed away, who's the next person in line and the next person? And I'll tell you generally, it typically goes kind of through the family tree.
Mm-hmm.
You'll find a series of things where it's like, it's going to go to, the surviving spouse. If you're married, it's going to go to the person that you were last married to, right? The person that you were married to at the time you passed. And if you have children, there are certain rules and regulations about when it passes directly to your children versus when it goes all to your surviving spouse. And if you had children from a previous relationship, there's language in these statutes in each state that says, well, this is how those things are distributed and this is how those things go through. And so it's just important to know that if you don't have a plan, the very thing that you might fear, which is government intervention, is that someone's going to make a decision about your assets and it's not going to be you. So that's a very important reason to say, you know what, I'm going to identify my last wishes and I'm going to create a will for myself.
I remember I had a relative pass some years ago, and we went to the bank, and I tried to tell family members that a power of attorney wasn't valid. They wouldn't listen to me. And the bank told them what I tried to tell them. A power of attorney was not valid. Can you address that to share with people when a power of attorney is valid and why the power of attorney is not, they should have a will?
So the important thing to understand about a power of attorney is someone is giving someone else the power to make decisions for them, right? So as an example, you, Troy, you create your power of attorney document. In that document, you, Troy, are giving the power, let's say, to your wife.
Mm-hmm.
I give my wife the power to access my financial accounts, to access any business interests, to access real estate, and to be able to make decisions on my behalf in the event that I can't make those decisions myself. And the power of attorney is typically going to be extremely detailed about what decisions your agent can make on your behalf and what decisions might require some extra steps, right? Also, understand that the language of the power of attorney tells you exactly what you need to know. It's power being given. So if someone passes away, for example, there's no one there to give that power. So you can't have a power of attorney that is active and able to be used if the person that gave the power has passed away. So the power of attorney is a living document. In the same way that you have healthcare like surrogates or healthcare power of attorney, it's a living document. It only exists while you are living, and it is revocable at any time. And it doesn't give you infinite powers. It gives you the powers that are listed in the document.
Now, Sandy, you work real estate. That's one of your areas of state, and you work a lot with real estate transactions and real estate. So what happens if a person has a home, they have a mortgage, and they created a will, and the will says this particular property goes to my daughter? What's the process? Is that valid, or is that some steps or some things, some hiccups that may happen?
So just to be clear about what a will does and what a will does not do. A will provides instructions. It does not transfer rights. So aside from being able to allow the distribution of personal effects.
Before you go further, you've got to say that again for the people in the back. Loud for the people in the back.
Yes. So a will provides instructions. So it's called a last will and testament. So it's you saying what it is that you want as your last wishes. It's you giving instructions on how you want things divided up, on where you want your things to go. But it really is just that, instructions. So if you are trying to give someone something that has a title, like real estate, like a bank account, like stocks or bonds, anything that has a title is going to be transferred according to the law, or by operation of the law, right? So just me saying in my will, I want my house to go to my sister or my daughter or my husband is not sufficient to transfer it. You will now have to go through a court process called probate. And depending on your state, that process may look different. But generally speaking, you're going through a court process that says, hey, I have this document that says this person is going to receive this property. Well, I need something official from the court saying, hey, we approve this will and we approve this transfer, so that you can now have the necessary paperwork you need for recording purposes with the property appraiser and things like that. So when it comes to things that have title, you're going to need something more than just the will in order to be able to access that transfer. Same with a bank account. You could leave a bank account to someone, right? But if you
Right.
didn't leave it as a notation on that account as a payable on death or a transferable on death with the bank, well, the bank is going to say, well, you need to get us something from the probate court that says this will has been approved, right? And now you have some document that the bank is going to be provided that says, well, this person is entitled to what's in this account based on this will, right? So it's not an automatic transfer of anything. It is instructions to your family. It is instructions to the court. It is instructions to the world at large.
So what I hear you saying, that a will is a document and it's needed. It provides instructions, but then there's some other behind the scenes operations that need to be in place before those instructions can be carried out. If there's some title addressed to it or some legality, then you've got to take care of that before that instructions can be fulfilled. Is that what I'm hearing?
Absolutely, because again, a will, it gives instructions. It does not automatically transfer anything. So if you have certain things that require some additional documents in order to have that transfer effective, then you're going to need to go through a probate court process. Now, a will can identify certain items that may be able to be transferred outright without anything else but the will. Example, I've seen instances where I've had clients take their will to the Division of Motor Vehicles if they're a surviving spouse, and the will says this vehicle goes to my, surviving spouse or my daughter or whatnot. And they're able to fill in some paperwork with the DMV and provide, the document. Now, I had a big situation with a family member taking the will to the DMV, and the person at the DMV read the information and they were like, well, nope, we're going to need a court order. This is not clear enough. This doesn't have enough information that we need. Now, as an attorney, the information was blatantly clear to me. But remember, you're not dealing with attorneys when you go to the DMV. You're dealing with everyday people who are working a job, and they have a job to do, and they're going to look at what they look at, and they're going to say yes, no, or maybe, right? So you're going to need to make sure that you clearly identify things that need to be transferred in a different manner prior to your death, so that your family members are not having to go through a court process. So there are deeds that can be done if you have real estate. There's things that you can do when it comes to bank accounts and investment accounts, stocks and bonds. So you may want to look into that. There's things that you can do with social media where you can identify who will take over your social media account, or whether you even want your social media account to continue after your passing, or who can access your email, if at all. So you need to think about those different, options.
So, Sandy, what happens in that instance? Someone passed, maybe they're a big influencer with social media, but they have no will. And the manager, social media manager, or whoever says that they want to get to and get access. What happens there? Is that going to be a court battle?
So there's a lot of different issues with social media. And one of the things that I encourage folks to do is take a look at the terms and conditions for your different social media platforms. I know that on YouTube, for example, there's a whole section that has to do with if somebody passes away that owns a YouTube channel. And there's some things that you can identify on your YouTube. I know Facebook has some things that you can do with identifying if you want your account to continue as like a legacy account or things like that. And the same happens with email and things like that. You can identify whether you even want your account to continue, whether you want family and friends to be able to dig through, your personal thoughts, ideas, and postings. So everything is going to be based on the terms and conditions of each of the programs. And it's important that I know that many times when we start on these platforms, we don't read, we just click, sign up, and I'm in. But it's important that as you're working through your estate planning process, as you're making decisions about your last wishes and what you want to happen, it's important that you start to take a look at those things. And it doesn't take too long. It's really just searching through these platforms. Like Google, you can search and say, well, what happens to my account if I pass away? And it'll take you through some steps, and you'll be able to find some links where you can create some responses to certain things, and make sure that your account goes where you want it to go.
There's so many complexities to this legal and leaving. You got intellectual property, you got non-physical assets, and it's just so many things. Take Aretha Franklin, Chadwick Boseman, DMX, these people. Did these people not even have wills? I know they didn't have an estate plan, but did they not even have wills?
So there were a couple of different situations going on with each of the people that you mentioned. So let's start with Aretha Franklin. I didn't do too much of a deep dive with Aretha, but I do know that she did have a will. In fact, she had more than one will. And part of the battle in the Aretha Franklin situation was one of those, which will is the right will?
Okay.
So sometimes that can become an issue. And it's important that if you make changes to your documents over time, that you make sure that you get rid of, the past document. Because when you're creating a new will, that means that you're trying to get rid of the previous, typically, unless you're just adjusting maybe a provision or a section. So it's important that you prepare for the fact that if I'm going to make changes, that I actually get rid of what I previously had in place, so that I'm now only operating with the new document. So I think that was a battle of a lot of different layers that had to do with different documents that were found. I think you mentioned Prince, right?
Yeah.
If I'm understanding correctly, I remember Prince didn't have any documents, and I think that he was just not interested in doing any kind of planning.
Yeah.
So that could have been a thing for his situation. Um, but when it comes to, let's say, Kobe Bryant years ago, Kobe Bryant has documents in place, but there was an issue with one of his documents where I believe the youngest child that was born was not included.
Correct.
Um, but they had to go through a court process, and it was, to my understanding, determined that you know it was his intention to
Mhm.
include all children. And so, those kinds of things tend to happen sometimes when you might have future children, and maybe your documents don't clearly outline, or maybe your documents give that intention or that impression, but that person's name or that identity is not specifically, prepared for, right? And so it brings an important point that even if you have estate planning documents in place, it doesn't mean that you're completely going to be excluded from having to go through a court process. You may very well have to go through a court process because of some deficiency, some issue, something that needed to be included that was not. So that's something to really consider and include in your thought.
You know, with that being said, so here's a scenario: husband has a will. He writes this will. Will's notarized. It's documented that he wants to leave his life insurance policy to the wife. The insurance policy has the former wife as the beneficiary and was never changed. Which one trumps which one? Now, his intentions, we talking about intentions, he put it in writing to leave it with the current wife. Which one would probably win in a court?
So that's going to be a tricky one, because when you get divorced from someone, there are certain things that are outlined in your final divorce decree that may very well answer that question. And also, there have been cases where that has been an issue, where somebody, failed to make a change to their designation. Um, I would say that it depends on what the divorce decree says. That's something that I know would be controlling in these types of situations. But also know that just in general, when you leave somebody as a beneficiary, and let's say you fail to remove them, maybe something changes and you fail to remove them, generally speaking, that person would be entitled to receive. But in a case of a marriage, because a marriage basically is a contract, and there are some things that happen when a marriage is ended, and there's some documents that outline, what the responsibilities are of each of the partners. I would definitely say that the divorce decree should address that type of situation.
I mean, and I'm sure I'm throwing that out. I'm sure it has happened, and
For
probably more
sure.
than once. And those are things that you think about. His intention. He has a will, but he never removed. And technically, beneficiaries trump any other thing, but it goes back, like I said, the divorce decree and all that. So I would
Right.
be interested in how that, if I hear one of those presently, how the case plays out in the end. What does the court say? Because that could probably go all the way to the Supreme Court, because it would be a fight between each other.
I mean, if there was a conflict where the divorce decree doesn't give any guidance, that would be one thing I would say.
Yeah.
But I'm I'm pretty certain, based on what I remember about these types of situations, that that divorce decree is going to incorporate something about that. And also, there may be some language in the insurance policy that addresses, if you're leaving a spouse as a beneficiary and if there's a divorce. I'm pretty sure at this stage there is some language that would have to be included there.
Yeah, well, it kind of made me think about this when you mentioned about Kobe Bryant, I remember hearing that story. You know, the one child, the child may have not been born, or the child was born but he didn't change it, you know, because we just automatically assume each child. For example, in the industry I'm in the insurance industry, if you pay for a rider and the child is not added, the other child are kind of automatically included, you know, within the family, you know, for additional children. But that could be, you know, somebody could challenge that if they're, you know, become an insurance company, you know, wants to challenge that because they don't want to pay the beneficiary the death benefit. So that could become a challenge. So August Make a Will Month. What are some tips that people can do to prepare a will?
So one of the major tips that I give is taking an inventory of everything that you own, everything that you have an interest in, everything that could potentially come to you, whether it be from other family members or, you know, other, you know, your relationships and things like that. Take an inventory of everything. Identify things that may need some other documents, right? If I own real estate, well, I may need to figure out, well, if something happens to me, well, what's going to happen to my real estate? Where do I want it to go?
Right.
If you have accounts, every single account should be accounted for in terms of, well, do I have a payable on death or a terminable on death? Do I have a beneficiary on those accounts? If I own investments like stocks, bonds, crypto, if I have any kind of retirement funds, if I have, you know, accounts owed to me, like people who owe me money or any of those types of things, you know, you need to have a full inventory of everything you own. And you should have somewhere safe where you put those things so that if something were to happen to you, the person that you trust should be able to access a running list of all the things that they'd need to look to, right? One of the worst things that I've experienced as an attorney, over 10 years of practice now, thinking back to some of the craziest situations that I've experienced. One was years ago where our firm was hired to help a family, and we literally had to go to this person's home who had passed away and dig through documents to find whether they had a will, to see if there were any accounts, any life insurance. Like, we had to dig through this person's personal effects. And unfortunately, there was a lot of stuff to dig through because this person had papers all over the place. There was all kinds of documents that we had to dig through. And it was just a little weird, you know, going through somebody else's things for the sake of doing that. And I had to do the same thing a number of years ago when my aunt passed away. I became tasked with trying to figure out what she had, trying to finalize her final arrangements, not knowing what she would have wanted at all. You know, we weren't that close. She wasn't somebody that liked to share information. You know, we have a lot of family members that, you know, they don't want people in their business. But the problem is when you become ill, guess what? Those family members that you don't want in your business are going to have to be in your business in order to be able to help you. So taking inventory is a very deep process. It's not just I'm writing down all the list of accounts I have and I'm done. No, it's thinking about, well, if something happens to me, are there people that I'm responsible for? Who's going to be responsible for those people, right? If you're caring for aging parents, if you're caring for family members who have any kind of disabilities, if you're caring for minor children, well, if something happens to me right now and I have a child, who's going to pick up that child from school? How are they going to know where the child goes to school, right? Like, there has to be an inventory of all of the responsibilities as well, so that if something happens, the person who steps in or the person who's responsible for stepping in is going to have something that they can turn to, and they won't have to start from scratch.
So you made me think about when you just said, so what happens, a parent passes, and in the will it says that they want the children to be left with the grandmother. But the father steps in and says, I'm the father, I want the children with me. How is that handled?
You know, Parenting situations are always a little bit touchy because generally speaking, if it's a husband and wife and wife passes, well, it would be natural for the children to go to husband unless there's a reason for them not to. And, of course, there's a court process and a rhyme and a reason for everything under the sun. But, I would generally say that the natural surviving parent would be the person that would be able to step in. Again, separating if there was some special circumstance, abuse, neglect, exploitation, if the children never lived with the other parent and maybe they lived with, a grandparent or something like that. Like there are special circumstances, but generally I would look to the other natural parent.
Gotcha. Yeah, I was just curious because these are just scenarios that typical that could happen in life. They're not way far fetched.
Sure.
And but the intent was, let's say the father was not in the child's life, and the intent was
Right.
to move the children with the grandparents. But the father steps up and say, "Hey, they're my children. I want to be able to
Yeah.
raise them." So
Well,
go ahead.
we're looking at two different things too. We're looking at the care of the children and any financials that come from the person that passed away. The
Yeah,
financials don't automatically go to the other natural parent. That is very, very important. Those financials could be, maintained by someone else who was appointed by the court to do so.
yeah,
Because any monies for a child that's under 18, depending on the amount, may be needing to be managed under a guardianship, depending on your state.
right.
Um, so that's something important to know, that just because I pass away doesn't mean that automatically, the surviving parent gets to immediately tap in and take any money I have that I'm designating for my children.
Yeah. Have you ever had a case like that, Sandy, where uh, the other parent wanted to get access to the funds?
Yeah, I mean, I've had a couple of situations like that, but again, those funds are for the kids.
Right,
So if someone passes away and they have minor children, and the minor children are the ones that are in line to receive according to how things are going to be distributed, depending on the amount, it'll go to the natural parent,
right,
the surviving natural parent, or it will have to be managed by a guardianship. Usually, in certain states, it'll be, a certain amount under. So let's say Florida, I think the number was like something like 15,000, and anything above 15,000 or something like that.
mhm.
Um, but it depends on your state, whether or not those things would be done in that manner.
Now, Sandy, does a will have to be notarized?
Ooh, that's a good question. So generally speaking, the answer to that is no.
Okay,
What happens when you have the document itself notarized? It's an affidavit that you're notarizing, that you're basically attaching as part of your will package. But your general will document itself, it's not a requirement per se, right? However, if you don't have a will that is self-proving and you don't have that attachment that is an affidavit attesting that this is the will that was drafted by this person and executed on this date with these two witnesses and notary present, then you may have to do some kind of an oath at the time that that will is brought forward with the probate court. And what that's going to create is an extra step in the probate court process where you're going to have to find one of the witnesses to the will, potentially, or you may have to find, you may have someone else who's going to attest that this document was this person's last will and testament. So you don't want to create extra steps in a process that is already nuanced.
true.
You want to keep it as simple as possible, if not avoid the process altogether.
Right, yeah, true. So, Sandy, I go to LegalZoom and I get my documents and I fill them out. It's gonna save me money.
It's free.
Right. What is your
Uh,
what's the word? What is your advice to someone's going LegalZoom?
So people can do whatever they want, is my general opinion, because whatever you choose to do, you're going to deal with the results of that, right? My thing is, if you're going to go to any kind of free service to do something that other individuals are paid to do, you need to consider the nature of that document. Um, you need to consider what it is that you're trying to do with your documents and whether or not you think it's wise to do that free. Because free comes with its own consequences.
Mm-hmm.
When you pay for a service, you're paying for a service. And you're paying for expertise, you're paying for skills, you're paying for someone who understands what happens on the other end of that document. So I'm always of the opinion that, again, you pay for what you get what you pay for, right?
Yeah.
So if you want free, well, understand, think about all the things that you use for free.
Mm-hmm.
So if I'm here on StreamYard and I'm using it for free, what does StreamYard want? They want people to know that I'm on StreamYard. So they're going to want to put their watermark. They're going to want to put some other little things and disclaimers and things like that. So it's not free, right? They're still promoting their business while I'm trying to do what I'm doing on the platform. So it's not free. We have a free account, right? Free account, but you're giving them your information. Your data is money for them. Your data is something of value. So you just need to take heed of, I know you want me to say my phrase, our lives are not fill in the blank. We can't just get a form and it's going to fit Troy and it's going to fit Sandy in the same way.
Right.
It just doesn't make sense, right?
Yep.
I don't have any children. I'm not married. Mm-hmm. Troy is married. Troy, you have children too.
Yes, child.
So Troy's married, he has children, and I have no children, I'm not married. Mm-hmm. So do you really think my document is going to look the same as Troy's document? No.
Right.
There are certain things that I'm going to have to be very concerned about and incorporate into my documents because I'm a person who is not married and does not have children. Whereas Troy, who is married and has children, has a few different layers that he has to be concerned about. I am somebody that has aging family members that I tend to. I'm somebody who has a family member who has a disability. I'm somebody that has other responsibilities for family that go beyond your typical things. And so I have to be able to make sure that my documents incorporate some coverage for those issues. Troy may have some different situations on his own, right? He may have a business. He may have aging family members. He may have children. He may have grandchildren. He may have, extended family members that he's caring for. And so there are things that he's going to have to outline in his documents that are different. So our lives are not fill in the blanks. So this concept of just going on and I'm going to click a few clicks and everything is going to be perfect and I'm going to have the document that I need and everything's going to be well is a fallacy. There's no way that happens. Now, are there possibilities that there are people that have some simpler situations in their lives? Absolutely. But that doesn't mean that you're going to have a document that's all encompassing when you're clicking a few clicks and you got something done in a few minutes. That makes no sense. So, I want people to really think about, what it is that you're trying to accomplish when you're getting documents created. And it's something that you're working on long term. It's not something that you create today and then all of a sudden, everything is good and you never touch the documents again. You're going to deal with these documents at some point in time again.
True. Well, Sandy, I want us to wrap it up. Final thoughts, and you can tell us on Thursday if you have decided what area you want to go. We'll try to make these 45 minutes to an hour. I do have a
for sure
event at the top of the hour, so final thoughts, and then if you got anything that you want to tell us about the upcoming rest of the series.
So I think one of my final points for today is it's very important that you do your research. There are so many things available to you at your fingertips at this stage of the game. And so there's no reason that you shouldn't be able to find, any pieces of information that you need when it comes to wills and trusts and power of attorney. So it's important that you try to get as much information as possible so that you can take advantage of a lot of the resources that are out here, because, you don't have to reinvent the wheel these days, right? There's a lot of resources available. There's a lot of free things going on. There's a lot of programs and software. But you also do have to be more concerned with making sure that you do things the right way, because there's a lot more at stake.
Yeah.
And we're using social media, we're using all of these different platforms. And so we have to make sure that we are doing things.
Well, it looks like I lost Sandy temporarily. Good old technology. Sandy, if you're talking, you're on mute because I can't hear you.
Uh-oh, did it take me off?
Yeah, yeah, it's spin. Uh,
Okay, I guess it didn't want me to go. What happened?
I don't know, but my very first live, this was a LinkedIn live. I had that issue, but it was vice versa. My camera went out, and I troubleshooted all kind of ways, couldn't get it to work. My very first LinkedIn live,
Oh Lord, it's
and so
not letting me. What the heck is happening right now?
we kept
All
going.
right, well, I'll make my final thoughts. So, oh, I think because my battery was low. Sorry. So, as a final thought, I would just say think carefully about what it is that you're trying to do. Think carefully about the intentions that you have. And don't look at this as a process of let me get the cheapest thing, or let me, this is not a inexpensive process, but it doesn't have to be super expensive, right? There are options out there more so than there were years ago. And so you just need to take advantage and try to get the best benefit. And as far as the rest of the series, I would like to spend the remaining three sessions of the series kind of talking about specific things. So we'll probably do a little deep dive into special situations when it comes to dealing with children and wills,
Okay.
Aging parents, you know, uh, disability and things like that. We'll probably talk a little bit about dealing with sibling issues.
Okay.
I always have a lot of sibling issues in probates because parents want to list a bunch of siblings as joint owners of things. And I think that's the absolute worst thing ever. And I'll tell you why when we speak about the sibling issues. And
Yes.
then I want to talk a little bit about family conversations, family meetings, family drama, and how it impacts the ability to get a will done properly. Because a lot of times, family members want to dictate what other family members have in their documents. Like, I'm a daughter, I'm going to tell my mom what she needs to put in her will.
Right.
Or
Yeah.
I'm a husband, I'm going to tell my wife what she's going to put in her will. Like, you can't do that,
Right.
right? Each person has the right to make certain decisions. And what happens is we're each going to have to probably take a look at some things that we have jointly. And maybe we need to make some changes before we get to the point where death and disability and incapacity become an issue.
Yeah.
So maybe we might need to sell that primary home, or maybe we need to decide if we're going to give it to one of the kids versus, tasking it to 4 or 5 kids when we know only one kid is going to actually spend the money and invest and take care of the property, and the others are going to be freeloaders, right? So we
Yeah.
have to keep in mind the different issues and things that occur.
True. Love it.
All right. Well, I'm going to go ahead and put up the little screen that shows folks where they can tune in, and when they can tune in
Okay.
to us for our future sessions, because I think it's important for folks to know. So August is National Make a Will Month, and we're talking about what happens if you don't have a will. So today, August 12th, is our first session. We'll also be here with you on Thursday, August 14th, Thursday, August 21st, and Thursday, August 28th. 7:30 p.m. Eastern, 6:30 p.m. Central. I'm Sandy B. Law, your attorney and author, and I have Troy Holt, our Chief Encouragement Officer, sharing the time here with me. we have a little QR code here. So if you scan this, you'll have the link for our future recordings. You can go to Troy's Facebook and YouTube. You can go to my Facebook or any of my social media, and you'll find this recording. But again, August is National Make a Will Month. Please don't hesitate to tune in with us. Send us your questions in advance if you'd like.
Yes.
But definitely participate in the conversation because we have lots to share, and we're very happy to do it.
Thank you, Sandy. Again, if you're watching live, watching on the replay, give us hashtag, what's going to be replay now, hashtag replay, and tell us where you're from. Please share, and thank you.
Thank you so much, guys. Stay with me, Troy. Let me just end this 1 second.